It's me, who else? And welcome to Mink Law Defamation News, where I speed through this week's top stories in defamation. I'm Cassandra Harner, and I am not a lawyer. I just work here. I'm sure you've seen the notorious letter that Trump was said to have sent to Epstein on his birthday. Trump calls the letter a fake. He says that before the story was published in the Wall Street Journal, he informed Rupert Murdoch, the owner of the journal, that it was a fake, but they published it anyway. Trump is now suing Murdoch and the journal for defamation. If Trump can prove that what he says is in fact true, that the letter is fake, and he warned Murdoch ahead of time, then he might actually have a case. This would prove the journal acted with actual malice, which would come up every time news media, journalism, and public figures are involved in defamation cases. Trump's legal team says that Murdoch's age and failing health make it difficult for him to testify in person at trial. Might this be a strategic move? I frankly lost track of how many defamation suits the president has filed and what he has been saying or not saying about his involvement with Epstein, and I don't want to talk about it anymore. So let's take a look at the next story. Time to show off my French lessons as I pronounce these names as hard as I can. French President Emmanuel Macron and his wife Brigitte have filed a defamation lawsuit against Candace Owens. The Macrons claim Owens spread verifiably false and devastating lies in her podcast series Becoming Brigitte, alleging that she was once a man and that the Macrons are blood relatives committing incest. Owens responded by calling the lawsuit a PR strategy to smear her character, an attempt to bully her and infringe on her First Amendment rights as an American journalist. Owens' spokesperson emphasized the lawsuit as a foreign government attacking free speech. The thing about free speech is defamation is not protected. So once again, we are dealing with public figures, which means that a plaintiff must prove, yes, actual malice, to succeed in the case. So if Owen can prove that she was acting in good faith as an ethical journalist, reporting on what she believes to be the facts according to verified research, then this could be a defense for actual malice. The wildest part of the story is that Owens also claims Trump called her personally to tell her to stop transvestigating Mrs. Macron. I feel like I'm being held upside down underwater. A federal judge in Manhattan has dismissed the Devin Nunes versus NBC defamation lawsuit. Nunes is the owner of Truth Social and cried defamation for comments made on the Rachel Maddow show. Maddow reported about Nunes' handling of a package from a pro-Russia Ukrainian legislator, Andriy Derkach. U.S. District Judge Kevin Castell ruled that no reasonable jury could find Maddow acted with, you guessed it, actual malice, when she stated Nunes refused to hand the package over to the FBI. Nunes claimed Maddow knew the package was promptly turned over, but the court determined Maddow did not have a high degree of awareness of probable falsity, that is, acted with reckless disregard for the truth. I have no idea how to prove someone didn't know something, but go on. The band Dutch Interior posted on Instagram about how Meta AI had added a search suggestion link that read Dutch Interior Controversy. This link promoted a hallucination about the band, misattributing its name to white supremacy.
Our last reel on the subject led to more fake summaries. People in our comments let us know that Meta AI had created additional lies that are so bad I don't think I can even repeat them in this video.
The band set the story straight, saying that the name comes from a series of paintings. They wondered, how can this misinformation be allowed? Good question. I, too, am waiting on a neat and tidy legal answer as AI continues to develop faster than our laws can be made. But if the band wanted to file for defamation, Meta AI may have potential for liability. Although I had a great time recently discovering these blatantly incorrect Meta AI suggestions when it described my ex as an influencer known for playing Guitar Flash with a score of, let me check my notes, 52,569 points on the song Devil Went Down to Georgia. But you know, it's been a while. I have one more bonus story for you that isn't technically defamation, but one of the most bizarre revenge porn cases I've heard since I started working here. A judge has dismissed the McDonald's drive-thru revenge porn lawsuit. While the plaintiff waited an inordinate amount of time in the drive-thru, a McDonald's employee allegedly took a photo of the plaintiff and posted it on Yelp, highlighting the plaintiff's exposed breast. The suit against the franchise owners alleged the unauthorized taking and dissemination of an intimate photo, otherwise known as revenge porn, as well as a claim of invasion of privacy. The plaintiff was unaware that she was exposed and that photos were being taken. The judge noted that it was not reasonably foreseeable for an employee to take and post a naked photo of a customer, suggesting that the incident occurred through inadvertence and circumstance. In other words, there was no way the franchise owners could have any responsibility or ability to prevent this nip slip photo, so the judge did not find them liable for the event. The dismissal highlights the challenges in holding businesses accountable for the actions of individual employees. There's been no update on whether there will be separate legal action against those employees. That's all I have for you today. I hope to stay abreast of the latest defamation news. I'm Cassandra Harner with Mink Law, and thanks for watching.